And Jess Brown-Fuller.
Thank you, Mr Pritchard. It's an honour to serve under your chairmanship, and I would like to thank all the honourable members who have spoken so thoughtfully today on this important topic, especially the member for Keighley and Ilkley for representing the Petitions Committee and certainly doing his homework, and for highlighting how mystified people often feel in a system where they go through a lengthy court process only to find out that their trial has been monetised or privatised, and they have to spend thousands of pounds to have access to a case that was theirs. And I'd like to pay tribute to all of the signatories from across the country, 200,000 people, and I believe that the general public have got behind this petition so strongly because they are surprised that people are not just entitled to transcripts of their own case, because, Mr Pritchard, justice must be accessible and it must be visible. Trust in our justice system is built upon transparency, upon seeing the work and the reasoning behind decisions that affect so many lives. This is vital for defendants and crucial for victims, and also for bereaved families like the Honourable Member for Bexley-Heath and Crayford spoke passionately about. And today we have achieved consensus, as was said by the member for North East Cambridgeshire, that if we are going to break down barriers for our constituents, which surely is the most important role we can play in this place, as the member for Hartlepool mentioned, then this is one of those things that we can do that will make a genuine difference to people across the country that are engaging with the justice system. So the Liberal Democrats have long campaigned on this issue, particularly through the work of my honourable friend, the member for Richmond. Her campaigning for her constituent Juliana, a victim of rape who was told she would be charged £7,500 for her transcript, has been inspiring and I believe has truly shifted the dial, and I thank her for her advocacy in this area. And she highlighted a very important fact, which is that her constituent was still battling with the harms of that trauma and didn't hear the case that she was the victim of. And in order to be able to move on, she needed to have that document. And what is clear and has been reflected in much of the testimony today, as well as in national support for this petition, is that for many victims, court transcripts are a vital part of their recovery, be it personal recovery or via therapy. But for too long and for too many, these have been out of reach, reserved for those who can afford what can be incredibly large sums. Providing free court transcripts for victims is about giving them the support and protection they deserve. Many trials are lengthy, they take place years after the event, and they can be very re-traumatising experiences, even when victims do not attend in person. And everyone will handle situations like these differently, but given that victims are among the most vulnerable in our society, they should be afforded as much support as possible to overcome these challenges. And that is why consistent free access to transcripts is vital, and they must be available beyond the 28 days after a trial concludes to access the unduly lenient scheme. Such measures would markedly improve the experiences of both victims and survivors. That is why we welcomed the cross-party work in the sentencing bill to introduce the provision of free sentencing remarks for all victims. I would like to again thank my honourable friend, the member for Richmond, but also Baroness Brinton in the other place, and the various ministers in the MOJ, including the minister who's answering today, who worked to achieve this vital first step. However, we do believe that it is a stepping stone towards providing all transcripts free of charge. And the timing of this debate coming to the House couldn't be more pertinent, with the return this week of the Victims and Courts Bill from the Lords, which now includes the Liberal Democrat amendment tabled by my noble friend Baroness Brinton. This amendment will give victims access free of charge to transcripts relating to the route to verdict. This will extend current provisions encompassing bail decisions and judicial summaries, and it would avoid many of the extortionate costs we have heard about today and provide victims with clarity regarding their cases. And I want to thank the Conservatives in the other place for their support on this amendment, and I urge the Government to get behind it on Wednesday. We will continue to fail victims without these provisions, and as with much of the Government's rhetoric around improving technology and the use of AI in the court estate, there is little excuse not to put these provisions in place as quickly as possible. Thank you.
Dr. Kieran Mullen.
Thank you, Mr Pritchard. It's a pleasure to serve under your chairmanship. Can I begin by thanking the member for Keighley and Ilkley for opening the debate on behalf of the Petitions Committee. He's proving himself to be a consistent and doughty champion on behalf of victims and the issues that they raised with him, and I also want to acknowledge the member for Richmond in her long-standing campaigns in this regard, and I welcome this opportunity to discuss this issue as part of a wider debate we're having about transparency in the justice system. And sadly, I can predict to some extent, I think, what the Minister will say. 14 years will make an appearance, lots of rhetoric about how terrible the previous government was, absence of any idea of how they would have managed the challenges it faced any differently. I can also be pretty confident about what the Minister won't say. There won't be any real engagement with the challenges of COVID and what they presented to our justice system, even though they truly were unprecedented. But that's the standard the Justice Minister and Labour have set, not just in justice, but across the government on issues like inflation, energy bills, no acceptance of the challenges facing the previous government, no acceptance of the things outside of the government's control, and so it shouldn't be any surprise when they are held to exactly the same standard. But in reality, this issue is a good example of what more fair-minded commentators accept as a multi-decades-long failure to give the justice system and those affected by it the priority and resources that it deserves. I'm sure that if the Minister and I together were to design the justice system from scratch, we would agree that free access to transcripts was important and should just be the default. But we are where we are, and sadly I'm realistic about the success we're going to have on transcripts today, even with a petition signed by an impressive 200,000 people. This is a government, after all, that tried to delete the Courts Desk archive, one of the biggest steps forward in transparency in our justice system in recent years. I raised this directly in the House because I found the decision to delete a unique archive of corrected and correlated court listings and data deeply concerning. In the absence of retrospective access to court transcripts, the work of journalists is absolutely vital, and Courts Desk have become a valuable tool for journalists, campaigners and others to seek to identify patterns in offending and expose failings in our justice system. Rather than seeking to